Gentleman yields back. Now recognize the gentleman from Texas for 5 minutes.
Thank you. Mr. Portuese, based on your work on digital competition policy, what have we learned about how broad ex-ante platform regulations such as the DMA affect the speed at which new technologies reach the market, particularly for small and medium-sized tech firms?
Thank you very much. These ex-ante type of regulations are what I call fundamentally precautionary. In Europe, we have this principle of precautionary principle, which stop acting, developing product and services, even if there's no actual harm, just a very remote, what we call hypothetical risks of something happening leads to prohibition. So what we've learned from this ex-ante type of regulations is that blanket regulation doesn't work in a sense that it's just over-deterring on innovations and leads to underinvestments because companies spend more time on compliance and councils and fees trying to understand the regulations that is always vague rather than focusing on innovation, deploying product. And I just want to agree with Representative Raskin when I say we need stronger enforcement. Yes, but that's why we don't need regulations. Regulation is the opposite of enforcement. And the greater risks for potentially corruptions or risks for consolidation is regulatory capture, is the risk of crony capitalism. And what we have is the greater amount of the number of regulations, the more we have these kind of regulatory dialogues between these large companies and the regulator behind closed door. And I prefer a system based on US antitrust where there's enforcement in court that is public and is based on evidence and effects-based analysis rather than regulatory potential capture between closed doors, between a regulator and a company, where each company is treated differently according to their political favors or others. So we need to reinforce the role of the courts and the judicial principles that are underlying the antitrust history.
And so I guess I've also heard that these laws are designed by foreign governments to kneecap American companies so that the local companies who are effectively exempted can get ahead. My question to you finally then is how many of these domestic companies are subject to these new rules, and can you explain how these foreign legislatures have carefully or not carefully designed their regulations to target American companies?
It's very interesting because the DMA was capturing most of the US tech companies. Now it's all US tech companies. Booking.com was the only Dutch European companies that could have been included into the DMA. Now Booking.com as a holding in Connecticut can be considered as an American company. And TikTok was regulated. Now with the sale of TikTok, we can consider TikTok as a US company when it comes to US. So all companies under the DMA are somehow American companies. Sometimes those regulations in other parts of the world, they try to include a local company to avoid overt discriminatory intent of those regulations, because otherwise they're going to be sued before the World Trade Organizations. But that doesn't mean that in effect they are disproportionately targeting US tech companies. To include one company out of 7 or 8 and the rest are all Americans, the point is digital sovereignty and to target US tech companies.
Thank you.
Wait, no, Mr. Singham seems to have some.
Oh, sorry, Mr. Singham. Go ahead.
I just wanted to come back very quickly on that question with regard to Korea specifically, and it relates to something that Congressman Raskin also said, which is this issue of cronyism that my colleague mentioned. What you see in Korea is that the US companies and the US platforms are targeted through the regulation and through the operation of the KFTC and some of the things that it does, which violate the principles that were talked about here in terms of predictable enforcement, due process, and competition on the merits that Congresswoman Ballant mentioned. What's happening is that the Chinese firms are linked to the Korean chaebol. They escape virtually all enforcement activities, and it's the US companies that are in the target crosshairs. And that is why I made the comments I made about delivering, by this kind of approach, you're delivering the markets in these sort of battleground countries to the China model and to Chinese companies.
Thank you. I appreciate that. I yield back.
Gentleman yields back. I'm going to recognize the gentlewoman from Wyoming for a unanimous consent request.
Thank you. I would like unanimous consent to enter into the record an article by Axios titled U.S. Intelligence Intervened with DOJ to Push HPE Juniper Merger. This article explains that it was not corruption, but U.S. national security interests against communist China-owned Huawei that led to the HPE Juniper settlement.
Without objection.